They convicted Kirk Bloodsworth of murdering 9-year-old Dawn Hamilton in 1985. Then a defense attorney found a cardboard box sitting forgotten in a judge's chambers closet. Evidence the state had told the court on the record no longer existed. Inside it, the one item of clothing that could prove they'd sentenced an innocent man to die. So why did nobody go looking for that box for 7 years? The official story was simple, and it convinced 2 separate juries. On July 25, 1984, in Rosedale, Maryland, a young girl was found beaten to death in the woods near a shopping center. 2 boys said they'd seen her walk off with a tall, thin man with sandy blonde hair and a mustache. A composite sketch went out. A tip came in naming Kirk Bloodsworth, a 23-year-old former Marine with no criminal record. 5 eyewitnesses put him near the scene. There was no physical evidence tying him to the crime, no fingerprints, no blood, no confession, but the identifications were enough. His first trial ended in a death sentence. A retrial, after an appeals court found a procedural error, ended in life imprisonment instead. The case was closed. Bloodsworth spent the next several years on death row insisting, to anyone who'd listen, that the man in the sketch wasn't him. The crack came in 1992, when a new kind of testing, DNA analysis using PCR amplification, which didn't exist as a courtroom tool in 1984, became available for old biological samples. Bloodsworth's attorney, Bob Morin, went looking for the physical evidence from the original case, the victim's underwear, stained with the killer's semen. Prosecutors had told the court years earlier that evidence from closed cases was routinely destroyed after appeals concluded. Morin was told the same thing. Then, almost by accident, someone checked a storage closet attached to the judge's own chambers, not the police property room, not the crime lab, but a leftover holding space nobody had inventoried in years. The box was still there, sealed, untouched, labeled with the case number in fading marker. That box shouldn't have existed, according to the trial record, and its existence changed everything the jury had been told. If the item inside had been tested in 1985, even with the cruder serology methods available then, it could have narrowed the pool of possible attackers dramatically. Instead, prosecutors built their case entirely on eyewitness memory. 2 children glancing at a stranger in a parking lot. Adults recalling a face weeks after a 5 o'clock news sketch had already shaped what they thought they'd seen. The forgotten box didn't just contain fabric. It contained the test nobody ran, sitting 15 minutes from the courtroom the entire time Bloodsworth was appealing for his life. Here's the part that should trouble you more than the mistake itself. Nobody was hiding that box out of malice. That's what made it almost impossible to find. Evidence rooms operate on retention schedules. After a set number of years or after appeals exhaust, property units are cleared to make space. The paperwork said this evidence had been processed for destruction. In practice, someone had pulled the sealed items during a chamber's move and set them aside instead of following through, and then it simply sat, unlogged, unsubpoenaed, invisible to any system that would have flagged it. There was no warrant that reached a closet nobody knew to search. The state didn't need to conceal it. The absence of a procedure did that on its own. In 1993, PCR testing on that evidence excluded Kirk Bloodsworth completely. He was released after nearly 9 years, becoming the first American sentenced to death and later exonerated by DNA. But the file wasn't finished. Investigators ran the DNA profile against a state database in 2003, a decade later, and it matched a man named Kimberly Shea Ruffner. Here's the detail that makes coincidence impossible. Ruffner had served time in the same prison as Bloodsworth for a separate assault, during the very years Bloodsworth sat there insisting he was innocent. He worked in the prison library. By some accounts, he handed Bloodsworth legal books, the actual killer, passing paperwork across a counter to the man serving his sentence. So who benefited from a forgotten closet? Not the state, which spent nearly a decade defending a conviction that evaporated the moment someone tested fabric they swore was gone. Not the real killer, who walked free for almost 20 years after the crime, close enough to touch the man taking the blame. The only honest answer is that the system benefited, because a case stayed closed, tidy, and unexamined for as long as nobody opened that box. Bloodsworth's case forced reforms in evidence retention, but reform isn't the same as certainty. Nobody has ever accounted for how many other boxes like his sat, and still sit, unlogged in closets attached to courthouses that finished their business years ago, cases marked solved, sitting one misplaced folder away from unraveling. The question this case leaves behind isn't whether the system can find the truth. It's how many rooms nobody's checked yet.